Hey everyone, I'm Mike Dahl. I'm one of the lawyers here at Valent Legal. In today's video, we're going to talk about how to win a slip and fall claim. If you've suffered an injury while on someone else's property, you likely have some questions. We have answers. This video seeks to help answer some of those common questions, but if you have further questions, feel free to comment down below or reach out to us directly for a free consultation. You can check us out at valentlegal.ca and follow us on Instagram, where we regularly post what we think is helpful information. So please continue leaving your questions down below, and let's get to it and talk about how to win a slip and fall claim. First question that people have if they're injured on someone else's property is, should I file a slip and fall claim? The answer is a personal one, but if you have suffered an injury, especially a significant injury, as a result of what you believe to be sort of haphazard conditions, then you'd be well advised to file a slip and fall claim. Most occupiers, most sort of building owners, businesses, have insurance to cover just this thing. And essentially you would be approaching their insurance company for compensation related to the injury that you've suffered as a consequence of substandard care. What do I mean by substandard care? All business owners, occupiers of property, landlords are held to a standard that is dictated by legislation. There's something called an Occupiers Liability Act. And that legislation imposes a burden on all businesses, property owners, to take reasonable steps to best ensure the safety and well-being of people who come into that business and onto that property. If you as a business or a landowner know about a hazard, ice for example, a puddle in a grocery store, then you have an obligation at law to take steps to address it. If you as a business owner or a landowner know even that there's a risk of those hazards, then you have an obligation at law to inspect for those risks. And so, a store, for example, at law has to, depending on the size of the store and what actually takes place there, has to ensure that there's a maintenance and an inspection regime in place to detect possible hazards. For example, grocery stores. They have an obligation to ensure that employees are regularly walking the store at defined intervals to be on the lookout for possible hazards, slipping hazards, for example. It is a well-known fact that people in grocery stores sometimes spill things. Sometimes there's a carton of milk that gets dropped, for example. And when that happens, that's a hazard. It's a slipping hazard, a puddle on a tiled floor. And grocery stores either knew about that hazard and didn't properly address it, or ought to have known about it, but because of failures in their inspection system, didn't do something to address it. In either of those situations, if someone slips and hurts themselves on that puddle, the store will be, at law, liable for the consequences of that fall. If you have been injured while on someone else's property, be it a business or someone's house, in order to be successful in a slip and fall claim, you have to prove negligence. You have to prove that business, that store did something, or more often didn't do something, which a reasonable store owner would or wouldn't do. And so a common example is failing to address a hazard, foreseeable risk of harm that they knew or ought to have known about. And if they fail to do that and someone is injured as a result, then they're liable. Common question that we're asked from folks who find themselves injured in a slip and fall accident is, what can I expect out of this? What type of damages will I be entitled to legally? We've discussed the concept of damages in other videos, and for slip and fall claims, it's no different. You are entitled to the damages commensurate with the extent of the injury and your losses. So common ones that, sort of everybody would be entitled to are damages for your pain and suffering. You were injured as a result of someone's negligence, and by virtue of that injury, you have pain and suffering. And the law provides something called general damages to compensate you for that pain and suffering. There is, in other videos, we've talked about this concept of a cap on pain and suffering or general damages. It's helpful to appreciate that there is no cap on general damages or pain and suffering awards in slip and fall occupier liability cases. That only applies where motor vehicle insurance is at play. Other common damages can include things like, income loss. If the slip and fall injury has resulted in you missing time from work. Cost of care. If you are out of pocket money in terms of treatment or special things you may need around your house, ramps or what have you as you recover, the insurance company of the business or the landowner is responsible for compensating you for those losses. If you have suffered a diminished ability to do your housework, the law provides compensation in terms of, replacement services for that loss. The amount of time a slip and fall lawsuit takes from sort of start to finish depends on a number of things. Most significantly, it will depend on the strength of your argument on liability. How obvious is it that the store, the business, the landowner is at fault, is negligent? If it's pretty self-evident on its face, then that is a case that will typically resolve within a year or two of the injury. We recommend not to rush that process. Certainly don't settle within the first few months if you have a significant injury, because at the end of the day, you only get one settlement in exchange for release, promising never to seek more compensation. It is wise then to wait to ensure you know the full extent of the injury. Is it going to be a lasting injury? Is it going to impair your ability to do the things you love before you talk settlement and resolution with an insurance company? But if liability is pretty self-evident on its face, it will generally take about a year or two after the injury to resolve the case. Oftentimes, liability or fault is not obvious. A business owner, common defense is to say, look, we did everything reasonable, and this injury is just an unfortunate consequence of things that are beyond our control. Winter in Nova Scotia being a common example. We were about to get to the hazard, and unfortunately, our customer was injured before we could get there, but our process of addressing hazards is a reasonable one. We're sorry this happened, but we're not at fault legally. If they take that position, things can take longer. You will likely find yourself in a lawsuit where there is discovery and disclosure, which we've talked about in prior videos. That process will take, on average, 2 to 4 years before eventual resolution. People who are injured in slip and fall accidents often approach us with sort of this basic question of, how can you guys help me? Why do I need a lawyer? And the answer is really twofold. One, lawyers help prove fault. It is the rare case that an insurance company for an occupier accepts fault. They will always argue that their insured is not responsible, or even if they are responsible, that you as a customer are equally responsible. You should have seen the puddle. You should have been wearing winter boots. And so when an insurance company pushes back with liability arguments, an experienced lawyer who specializes in slip and fall claims is able to best address those arguments by pointing to case law, to pointing to standards. Also, oftentimes it's the case in occupier liability claims that expert evidence is needed. For example, was the setup of the store consistent with the Building Code of Canada, for example? It is most often the case that, if you're going to make an allegation of a breach of the Building Code of Canada, you need an engineer to speak to that issue. Lawyers who then specialize in this work know how to consult with and retain those experts. So lawyers help prove liability by knowing the standards, knowing the case law, and knowing which experts may or may not be needed. But they also help prove damages, right? So once liability is established, what are the extent of the losses? And so in order to get fair, maximal compensation for those losses, a personal injury lawyer experienced in this area knows, again, how to get the right experts, all the different categories of loss that an injured person can claim, and how to best present the case in a way that would be compelling to an insurance company ultimately responsible for paying the damages. All right, everyone. I hope this video helped answer some of your questions around how to make a slip and fall claim successful. If you have any more questions, feel free to comment down below or reach out to us for a free consultation. We'd be happy to chat with you. And also check out our website, valentlegal.ca, and follow us on Instagram for more free information.